A felony case can be broken down into 4 stages. The third stage is the preliminary hearing. A preliminary hearing is an evidentiary hearing which takes place in front of a judge and not a jury. Certain evidence is considered, including hearsay evidence. Many cases are resolved prior to the preliminary hearing. If a case cannot be resolved at the pretrial stage, the defense attorney may make one last-ditch effort to resolve the case on the day of the preliminary hearing. If a case cannot be resolved, the defense will announce ready for preliminary hearing. Depending on prosecution readiness and the availability of a courtroom, the preliminary hearing may be heard later that day, or it may trail until it can be heard. At the preliminary hearing, the prosecution must simply present evidence that there is probable cause to believe that the defendant committed the crime or crimes charged. California law permits the prosecution to meet this burden by calling only one law enforcement officer who handled the case. The prosecutor does not have to prove his or her case beyond a reasonable doubt. The reasonable doubt standard is the higher standard which is required at trial. Therefore, it is usually not difficult for the prosecution to win the preliminary hearing and for the judge to order the defendant to be held over for trial.